Thank you very much, ladies and gentlemen.
Thank you, Attorney Tombasco. Mr. Lychwick, would you like to give an opening statement at this time?
Yes, I would.
All right, you may proceed.
Ladies and gentlemen of the jury, quite simply, I am not guilty of this crime. I feel sorry for my poor neighbor, but I did not know him well enough to have any animus against him even, and I have never killed anyone in my life. The largest warm-blooded animal that I've ever killed was a skunk that walked in front of my car by accident years ago. I am not a killer. The police in this matter have a largely circumstantial case. I don't know how exactly they circumvene on me, but I simply did not do this. I am unprepared for this trial. I am in poor health. I was in poor health and doctoring at the time that they arrested me, and they knew that. The police have made gross exaggerations in their reports, and I do not recognize that firearm. This is the first time I am seeing a picture of the firearm used in this murder, and I do not recognize it. That was not in the trunk of my car when they stopped me. They did not have a warrant when they stopped me.
Objection.
The objection is overruled at this time. The warrant was discussed in the state's opening. Mr. Lychwick, though, I will remind you that you're venturing a little into argumentative territory, so I want you to just focus on what you believe the evidence will show, and you can infer arguments in your closing arguments, okay?
All right.
Go ahead.
I caught some gross exaggerations immediately with the prosecution's opening statement here. They're telling you that Detective Stern had presented me with a copy of the search warrant, which he did when they went and destroyed my apartment. And in the search warrant, Mr. Carlos's name was on the search warrant. And I knew everyone in our building there, down at the bottom of the hill here, knew that Mr. Carlos was being looked for, that he was missing. Detective Pavlik of the Waukesha Police Department took an initial statement from me the night that they were examining the crime scene when I was returning from a social engagement. I gave my statement to him, and he asked me if I had seen Mr. Carlos around anywhere recently, and I told him, of course, that I had not. This is a gross exaggeration. I don't know how the detective can wear his badge with honor and blow something like this out of proportion and use this as an excuse to center on me in this affair. I was never walking around in the area where the poor man was found. I was never in that area. And yet the state is telling you that I was walking in the area where the poor man was found. I was not. I was never in that area. Quite the contrary. The man who discovered the body and was an initial suspect of this crime, Mr. Polly, who is now missing.
Objection. Relevance.
Mr. Lychwick, I'm going to sustain that objection. I'm not sure how the testimony is going to come out regarding that, but I think that's something that's outside the scope of this trial. So I want you to focus on the evidence that will be shown in this trial. You may proceed.
I would like to say that Mr. Polly was the one who was...
Objection.
I don't know what his next statement's going to be. What were you going to say, Mr. Lychwick? You want to say that Mr. Polly is...
Mr. Polly, a very suspicious character in this building to begin with, was seen quite frequently in the area where the poor man was found, where the remains were found of this poor man.
Hang on one moment. Attorney Tombasco, are you objecting to that statement?
Absolutely.
Why is that?
Because it's contrary to this court's pretrial rulings regarding Denny evidence.
Mr. Lychwick, I'm sustaining that objection. At this point, I want you to focus on the state's opening, your opening, the evidence that you believe will be presented, and I'm reminding you of the scope of some of my pretrial rulings about what can come in and what cannot come in into evidence. You may proceed.
The defense, in my defense here, The prosecution is maintaining that Mr. Lefebvre's camera captured me walking around in the area that I lived in. I had reasons for being out the few times that I went out at night. As anybody, I'm living in a wilderness area. We're not allowed pets in my buildings. I put food out for the rabbits. I carry a rake to clean up the area under the tree where I leave the lettuce rinds that I give the rabbits. I also curious as to where the local possums that are supposed to hang out in our pine trees live. And I was accused by the prosecution here of carrying a firearm when I was out. As you'll see in the videos that Mr. Lefebvre took with his trail camera, that is not a firearm, and it has been recognized as not a firearm. And if the state maintains that it is, I will object to that, because it is a flashlight in an old camera case on my belt. I did not walk around with a pistol. I did have a pistol in one of the bags that they found during their illegal car stop, and it was
Objection.
The objection?
Again, he's violating the court's pretrial ruling.
Okay. Mr. Lychwick, there were motions heard before the trial about legality and illegality of any searches. The court has made a ruling that the searches in this case were valid and they were constitutional. So I'm not going to permit arguments that the searches were not legal. You may continue.
Well, the police did not have a search warrant at the time that they took my car.
Objection.
Again, that, Mr. Lychwick, is something that would be ruled on pretrial. It's not a trial issue for this jury to determine whether or not there was a warrant present. You may continue.
Oh, I'm up against a lot here, ladies and gentlemen of the jury. I am a God-fearing man. I'm telling you, I did not know the poor victim. I did not even know him to where if I saw him in a store or he saw me, we would have said anything to one another. It is a 16-unit apartment building. We have multiple people living in each unit, and I have my lady friend, and I spend a lot of time away from my 16-unit building, doing my own business, minding my own business. We all are good people in that building. We mind our own business. As I told the Channel 4 reporter who interviewed me shortly after Mr. Carlos was found, and this whole thing blew over. And as I told Channel 4, Leslie Clough of Channel 4, who interviewed me, this whole thing was bizarre. Right around Halloween, they find the poor man, and nobody heard anything or saw anything. It was just bizarre. And as I told Ms. Clough, we're all good people in the building. We mind our own business. We're on different schedules. Again, as far as me and the victim go, I really never saw him that much. The closest look I've ever had of him was at the picture they just showed on the screen this morning. There was another misstatement made by the prosecution, and the prosecution is maintaining that that I wrote some that they had evidence of the victim's name in my apartment written on a piece of paper. That is totally false. I had nothing at all with the victim's name on it. I did not know the victim that well. I'm sure he was a very nice man and everything, but I would have liked to have known him probably, but I simply did not. We were all on, I say again, different schedules, moving around on different time frames and timelines. I am acting as my own defense because
Objection.
Mr. Lychwick, I don't know the jury needs to know the reasons for that. It is your decision to make. You have exercised your right to represent yourself. The court has granted that request, and that's the end of it. The reasons for that or behind that is not anything the jury needs to consider.
it was an excruciating decision, Your Honor.
Mr. Lychwick, that's not anything the jury needs to consider in trying this case. That's not for the jury to consider in their deliberations, okay? So move on, please.
Well, I enter these proceedings under protest as well, because I am not an attorney, and I have no access to my assets right now, and I had no access to telephone or computer.
Judge, I'm objecting to this. I don't see the possible relevance to the evidence.
The objection is sustained. This is all not relevant, Mr. Lychwick. You are in court now representing yourself. You are held to the standards of an attorney. And you, if you have anything else regarding what you anticipate the evidence to show in this case that's relevant, you may present that.
I have developed evidence through the discovery process in this case that strongly will prove that the Waukesha Police Department, namely 5 to 7 of these officers and detectives involved in this case, have compiled this evidence on their own. That they have falsely introduced this evidence against me. It is not just. It is not legal what they are doing. I came across hard evidence of their abilities and their intents and their lack of ethics when I received discovery evidence in the form of Axon body cameras from the night that they took my car on 1st December 2024. I found that there were sections missing from the body camera footage, including audio sections that were reworked and redubbed. I have not been able to get the state public defender to provide for the minimal cost to analyze the footage and the audio section of the footage to prove my point and to prove tampering and tainted evidence in this case, which should have resulted in this case being thrown out at least 8 months ago. It should not have come this far. But I have not been able to get my only source of defense, which was the State Public Defender's Office, who I took at face value, owing to their title, to provide me with the minimal, I say again, the minimal amount of cost to develop the evidence, which is a very cost effective and relatively easy method that an amateur could process this evidence and show from the body camera footage and pulling it apart on a video editor, which is present on any computer. The fact that the Waukesha Police Department had doctored this film footage and doctored the audio portion of the film footage. What they cut out was the fact that they bumbled the car stop. It was completely contrived. As soon as I was pulling into the gas station from Appleton, Wisconsin, where they followed me apparently, they stopped me at the driveway of the gas station, and Officer C.D. Baca exiting his police cruiser along with Officer Tyndall trip over each other and start laughing. One says, "Stopped going 35 and a 25," and they start laughing. And the other one says, "Stopped going 35 in a 25. And they cut that out. And then I was offered a ride home when Detective Stern over here offered me a ride home because he said he was going to seize my car and have a warrant typed up at the police station so they could search the car. And I accepted the ride home down the hill from the Quick Trip gas station here on Pewaukee Road because it was quite cold and I wasn't feeling well. And Officer C.D. Baca of the Waukesha Police Department offered to take me home. And I tried making some small talk with him in the police cruiser. I just asked him if he'd catch any of the football games on recently or anything. And then when he let me out of the police cruiser in my driveway, which was dark and foreboding at that hour, being winter going towards 6:30 in the evening, Officer C.D. Baca did proceed to threaten me. He stated that I had better back them up on the fact that they're stopping me for speeding, going 35 miles an hour in a 25 mile an hour zone, which, by the way, does not exist on Pewaukee Road in the area where they stopped me. And I looked at he was standing in the shadows with another officer behind him who also pulled up in a police cruiser in my driveway. And they were holding onto their pistols. They had their hands on their pistols in a threatening manner. And I didn't know what was going to happen. And I looked at them, which you'll still see on the body camera footage if they show it to you, my reaction to C.D. Baca's threats are, yeah, all right, God. And I just wanted to get out of there and get into my apartment at that point. That they left into the body camera footage, but otherwise they have me saying, sure, the words coming out of my mouth were not those that I actually stated that night, which is tampering with the evidence, which is fraud. I was made to say, as you'll see on their version of the body camera footage, definitely, I agree with you. You know, have a good night and all this kind of stuff. That was not in the original Axon body camera footage filmed that night by the two police officers. That is tampering with evidence. I have tried to bring that before the court. I wanted to. I have the chain of custody of that evidence here, which shows considerable attention to Officer C.D. Baca's Axion body camera footage and Officer Tyndall's body camera footage. I can show that according to the jargon used with digital technology now, they call the data acquired by the filming and the audio portion of any body camera footage, and indeed many of the footage that we ourselves are prone to photographing when we use our cell phones and everything, is called checksum data. And in the evidence that I have in my disposal, which was presented to me on discovery by the prosecution and the police, I'm assuming they didn't think that me and my defense would come across this, but I did, and it clearly shows that they have changed this checksum data at least twice on C.D. Baca's body camera footage. Again, I strongly urge the jury to consider the tampering of evidence in this case. This case should have been dismissed at least 8 months ago when I discovered this evidence, which was given to me late by my first state public defender attorney, who was grossly inadequate and not providing me the correct defense that I needed, and I was forced to terminate him as my public defender. I emphatically deny any involvement in this crime. I am a law-abiding citizen. I am a good Christian of the Lutheran faith. I am a responsible citizen. I am an ex-police officer myself. I served as a security police officer in the United States Air Force. If this trial proceeds in a manner which which should deny me the justice that, in large part, I am really not qualified to oversee, as I am not a trained attorney. This will be a travesty of justice. I ask you to please consider the fact that a serious wrong is being perpetrated here. It will serve nobody if the state and the police, the several police officers of the many good police officers in the Waukesha Police Department have their way here. For one thing, the victim and his family will not receive justice. And they should definitely receive justice. The killer or killers, in my personal opinion, I think more than one person was involved in this homicide.
Objection.
Mr. Lychwick, consistent with the court's pretrial rulings on Denny evidence, the court will sustain that objection. It's also, the court will sustain the objection. Anything else, Mr. Lychwick?
Well, yes, Your Honor. Is that Denny evidence?
Yes.
And I must ask you to consider the fact that a person is considered innocent until proven guilty in this country. And I certainly am not guilty of this crime. And if a travesty of justice is allowed to take place at the culmination of this trial, the perpetrators of this crime will be allowed to roam free and perhaps kill again. You should consider that. The police should be put on the track of whoever did this to this man again, because while I'm in custody here, the state is under the false impression that they have their man, if you will, and they're not looking for the killer anymore. That is a serious miscarriage of justice in itself. That is a serious safety issue for public at large. I ask you to please weigh that in here as well. Ladies and gentlemen of the jury, I ask you to do your best, and I thank you for coming today and doing your duty as a citizen. I would have done the same thing. Thank you.
Thank you. All right, ladies and gentlemen, I will remind you that opening statements are not evidence. At this point in this case, you have heard exactly zero evidence. There's no evidence in this case yet presented to you. The only thing that's been presented is opening statements, and those are not evidence. So as you take a break for lunch, I will caution you to not discuss this case amongst yourselves. Don't come to any conclusions yet. You can certainly call to loved ones and check in and just state that you got selected for a jury. This is the trial you're on. But otherwise, don't say anything about the case so far or this process. Also, do not seek out any information on social media or news or Twitter or X or anything like that while you are on break. It is 12:27 right now. I want to give you time to take a break and get lunch. Let's reconvene at 1:40 p.m. and we should be ready to start the evidence at that time.
All right, the jury.
You may be seated.
We are now outside the presence of the jury. Mr. Lychwick, I just want to caution you on one thing. You made the statement that you are here in custody. Great efforts are being undertaken here to make sure the jury doesn't consider the fact that you're in custody. So it may be beneficial to you if you try to refrain from making that known to the jury. I know the state probably was on the verge of objecting to that, but didn't want to call undue attention to it, and I didn't want to interrupt and cause undue attention to it. It seemed more of an offhand comment, but nonetheless, it is for your benefit and your protection during this case to not have the jury know that.
Your Honor, I think it's an important facet of this case because it shows the fact that it's part of the fact of the reason why I'm having trouble defending myself and don't have counsel and am so unprepared to defend myself.
And it's not. It's not. It's not anything the jury is to consider. It should not sway their decision one way or the other, whether or not you're in custody. And you are your attorney, and you are held to the standards of an attorney. And whether that attorney is well prepared or not prepared at all, nonetheless, the trial's going. So that is not to be considered by the jury either. Any further statements about your preparedness, this being a travesty of justice, you not having sufficient time to review discovery, things like that, I'm not going to let that go any further. That's not relevant for the jury. It's not evidence, and it has no place in the trial. Understood?
With reluctance.
Okay. We are adjourned until 12:40. Anything else from the state?
I would also ask that the court admonish Mr. Lychwick to not make any more statements regarding his prior counsel being ineffective. That's quite frankly his opinion. There has been no finding by this court or Judge Shane Bourne for the time that she presided over this case that any counsel has been ineffective. And so I think that is completely inappropriate for Mr. Lychwick to be arguing that as well.
Attorney Thompson, Attorney Jones withdrew at the defendant's request, correct?
That is correct.
Okay. So, Mr. Lychwick, I think that's a fair point, too, that the state makes. Both of your prior attorneys withdrew at your request, and you've made the decision to represent yourself. So calling your prior counsel ineffective or saying that or implying that the public defender's office hasn't met your needs, things of that nature, are also irrelevant, too. And that goes to the court's finding that you are competent to represent yourself, and I granted your motion to represent yourself. That's as far as it goes. All the jury needs to know is that you're representing yourself pursuant to the Constitution. All right, we are adjourned until 12:40.